Welcome back to the channel. If you're navigating the US immigration system, you know that rules can change in the blink of an eye. This week, we're covering some of the most massive and sweeping policy shifts of 2026. From USCIS adopting a strict new stance on application denials to a brand new public charge rule and a record-breaking processing backlog, there's a lot of critical information you need to know to protect your immigration journey. Let's dive right into this week's essential US immigration news. First up, a major policy update that took effect immediately August 5th, 2026. USCIS has updated its policy to allow officers to deny immigration applications and petitions without first issuing a request for evidence or a notice of intent to deny. What does this actually mean for you? In recent years, if you forgot a required document or failed to establish full eligibility in your initial packet, USCIS officers were generally encouraged to send you a request for evidence, giving you a second chance to fix the mistake. That safety net is now gone. Under this new policy, officers have the discretion to deny your case outright if the required initial evidence is missing at the moment you file. The agency's goal is to cut down on incomplete filings, meaning they are now held to a strict eligibility at the time of filing standard. Furthermore, USCIS clarified that even if they do decide to issue an RFE, they can now set much shorter response deadlines. Previously, applicants often received a standard 12 weeks to reply. Now, 12 weeks is simply the maximum outer limit, not the default, and officers can demand a much faster turnaround. The takeaway here is clear. Submitting a bare bones or placeholder application is incredibly risky. Complete and perfect, accurate filings are more important than ever to avoid an outright denial and losing your filing fee. Moving on to our second major update. A critical change to the public charge rule is just weeks away. Beginning September 18th, 2026, USCIS will apply a much broader public charge standard when reviewing certain green card applications, particularly family-based filings. Under the previous regulations, officers generally only looked at specific cash assistance programs or long-term institutionalization. However, under this new rule, immigration officers will have broader discretion to consider an applicant's use of means-tested public benefit. This includes Medicaid, SNAP, and housing assistance as part of a case-by-case assessment. It is important to note that this change applies only to those specific benefits received on or after September 18th, and it generally affects Form I-485 applications filed on or after that date. If you're preparing to file your green card application, you need to be aware that a new version of Form I-485 will likely be required starting September 18th, and older editions could be rejected. If your application is complete and you're eligible right now, you might want to finalize your paperwork before the September 18th deadline so your case is evaluated under the older, narrower standard. Next, let's talk about exchange visitors. The State Department has proposed significant updates to J-1 exchange visitor program rules. These proposed changes aim to update exactly how exchange visitor status is managed across the board. The proposal brings several strict clarifications, including defining exactly when sponsors must terminate a participant's program, and notably, it gives the State Department limited authority to terminate programs directly. The update also plans to streamline extension and reinstatement procedures by using current SEVIS functionality, and it adds strict new definitions for what constitutes unauthorized employment and valid program status. Additionally, the proposal removes a separate extension provision specifically for AU pairs. If you're a J-1 sponsor or participant, you have until September 28th, 2026 to submit public comments on these proposed changes. In another massive shift, USCIS has fundamentally changed the Affirmative asylum referral process. The Department of Homeland Security issued an interim final rule, which took effect on July 28, 2026, allowing USCIS to refer certain affirmative asylum applications directly to immigration court without first conducting an asylum interview. Historically, affirmative asylum seekers would have an interview with the USCIS officer, serving as their chance to explain their story. Now, to reduce the massive system backlog, USCIS can refer cases based entirely on the written record alone. While interviews will still be conducted before an actual grant or denial of asylum by USCIS, a referral to an immigration judge means your case moves to the defensive asylum process. The rule also removes the requirement that referral letters include a credibility assessment. Because you may not get a preliminary interview, this means that your initial Form I-589 application and your supporting written evidence must be incredibly thorough and well documented right from the start. Public comments for this rule are also due by September 28th. Finally, let's address the unprecedented processing delay. According to new data from the American Immigration Council for the first quarter of fiscal year 2026, USCIS processing has slowed caseload significantly. The agency's pending caseload has ballooned to a record 11.3 million applications and petitions. This staggering backlog means that processing times have nearly doubled, reaching an average backlog clearance time of 18.6 months. For some green card categories, applicants are waiting well over 2 years. Alongside these delays, denial rates have increased across several key immigration categories, specifically for employment-based petitions like the EB-1 Extraordinary Ability and EB-2 National Interest Waiver categories. This reflects a much more challenging and strict education environment. With a backlog this massive and scrutiny at an all-time high, getting your application right the first time, filing as early as possible, and monitoring your case status online are your best defenses against falling into legal limbo. Thank you for tuning in to this week's Immigration Update. Please remember that the information provided in this video is for educational and informational purposes only and does not constitute legal advice. Because immigration laws are incredibly complex and constantly changing, we highly recommend that you consult with an expert, licensed immigration lawyer to discuss the specific details of your individual case before filing any paperwork. Stay informed, stay prepared, and we will see you in the next video.